Okay, so I think we can begin if everyone's ready. I have Pallavi spotlighted. Okay, so welcome everyone to today's webinar. It's going to be about how to navigate the criminal justice system, especially when it comes to domestic violence and associated crimes. And our speaker for the day is Pallavi Dhawan. Pallavi Dhawan is a recipient of the 2019 LACBA Prosecutor of the Year Award. She's dedicated her entire professional career to speaking up on behalf of the most vulnerable victims, women, children that are subjected to violence in their homes. And she's a Fulbright specialist in domestic violence and child abuse. So she's the director of domestic violence policy at Los Angeles City Attorney's Office. Furthermore, she regularly trains on domestic violence intersections in the law and also works to develop best practices in this field, including helping develop California Senate Bill 1141, 2020, and 1141, which was added to legislation in 2020. This defined the coercive control of the family code definition of domestic violence. Since then it's been replicated across the nation. She's a well-renowned published writer with a number of articles to her name and is constantly working on ways to improve the lives of domestic violence survivors. She currently serves on the Los Angeles City Attorney's Office, and lastly, her alma mater is University of California, Los Angeles School of Law, both bachelor's and JD. So yes, a lot of titles to her name. Pallavi Dhawan, thank you for coming in today.
My pleasure. One thing I do want to add to that lovely introduction is that I'm also on the Saahas board, and I'm so happy to be here to support the work that Saahas does. I don't know if everyone on this call is familiar with Saahas. I wonder, Zeel, if you want to say a couple of words about the work, or maybe Payal, just so I can, you can make space for that if you want to do that now or at the end of the webinar, whatever you prefer.
Oh, thank you. Thank you for that. Yes, so Saahas For Cause, we work in the community, in the South Asian community, not just for aftercare for victims, but to prevent it for the society as a whole. So we work in the community through various channels, trying to not just prevent domestic violence, but overall uplift the lives and potential of our community members. So feel free to promote the work or even join us as a volunteer or even more. And just let's fight the cause. Fight for the cause.
Yeah, so I'm really happy to be here to join Saahas for this presentation. Thank you, Saahas, for always making space to talk about this very important issue that is near and dear to my heart, and I know to so many of you on this call. So the title of this presentation today is Criminal Justice System Navigation. And that is what we're going to talk about, but it's a little bit, I wouldn't say misleading, but it's not the most, it's not entirely accurate because, and it's hard to capture this. The reason for this slight kind of caveat that I'm putting out there is because it's so hard to capture what I want to talk about and what I think survivors need to hear about. And when we talk about domestic violence, that term itself, I want to explore. I'm all about, talking about language, the words that we use. And also when we talk about criminal justice system navigation, we're going to talk about it with an understanding and a recognition that survivors are navigating multiple systems at once, including the family court system, immigration systems, dependency court, and yes, criminal court as well. So built into this title is that recognition that a title cannot always say it all. And so we're going to unpack it as we move through the presentation so that we understand the ways in which The words that we use are really important for survivors. Definitions are important. Laws are important. And the intersections between different bodies of law are also really important.
Mm.
So with that, I want to start with a definition. It's not the only definition, but it's a definition of domestic violence. And it's the definition that is found in the Penal Code, which is the body of law that governs criminal cases in California. And this is the area of law where I have spent most of my career prosecuting domestic violence cases in the DA's office. Now I'm in the city attorney's office. And so I still spend a lot of time in this field. And we'll talk in a moment about the differences between those two offices. But I want to take a global view first of how domestic violence is defined in the Penal Code. So it's defined as intentionally or recklessly causing or attempting to cause bodily injury or placing another person in reasonable apprehension of imminent serious bodily injury to himself or herself or another person. And then victim of domestic violence has a definition in the Penal Code as well that references the nature of the relationship with the abuser or offender in the form of a spouse, a cohabitant, former spouse, former cohabitant. We're talking primarily about intimate relationships or former intimate relationships between the victim and the defendant. So what you'll notice about this definition, especially when we're talking about the conduct, is that it's really focused on physical injury or the threat of physical injury. And that is not, that does not capture this full spectrum of what survivors experience when they experience the harm of domestic violence. And that is why when I started this presentation, I said we have to unpack that phrase because the term itself, domestic or even intimate partner violence, has in its language a focus on violence. And when we talk about violence in the Penal Code, and even I think in common, in just day-to-day language, we are usually talking or thinking about physical harm. And I think that's just
one aspect.
Yeah, it's just the nature of the term and the language, which is why I sort of encourage all of you to think about, what comes to mind when you think of domestic violence. And typically the answer when I ask this question is physical harm. And that is what the Penal Code mirrors for us. It's physical harm and also that threat of physical harm. That is not a given, though, and it's not the case in the Family Code, which has a much broader definition of domestic violence. And actually, it has a broader definition of victim as well. So the victim, we'll start with that, of domestic violence in the family court context includes the Penal Code definition of victim, but it also includes the child of a party, and it includes relatives, like close relatives, siblings, and parents. So it's broader in that sense. It's a lot broader in terms of the harm of domestic violence and the definition of domestic abuse. In fact, it refers to domestic abuse, and it specifically has this language that abuse is not limited to the actual infliction of physical injury or assault, although those harms are covered in 1 through 3 of that definition. There's another component to domestic abuse in the Family Code that is referenced according to section 6320. And then we again have this language that it's not limited to the actual infliction of physical injury or assault. When you look to section 6320 of the Family Code, which is cross-referenced in that definition of domestic abuse, you'll see a list of different types of behavior. Now, these are all behaviors that can form the basis for a restraining order in family court. And I want to flag one clause there, which we'll talk about in more detail, and that is disturbing the peace of the other party. which is a really broad sort of catch-all category. And it has been defined, it has a definition in case law. And that legislation that Zeal was talking about at the beginning of the presentation that added the definition of coercive control to the family code, that builds on this section, and it builds on the definition of disturbing the peace. So something to remember here is that there is a definition of disturbing the peace in the penal code. And that definition is very different than the family code definition. So disturbing the peace in the penal code means like a public disturbance, playing loud music, loud parties, fighting in public. That is not the definition of disturbing the peace in the family code. So the family code definition refers to the destruction of an individual person's mental or emotional calm. I'm going to spend a little bit more time on this. Disturbing the peace is conduct. Now, this is, again, in the family code, conduct that, based on the totality of the circumstances, destroys the mental or emotional calm of the other party. It can be committed directly or indirectly through the use of a third party, maybe other family members, for instance. And it can be committed by any method or means, including through electronic devices.
Okay.
Now, that coercive control legislation was, the point of it was to name a harm that a lot of survivors suffer that previously hadn't been named, at least in California, in the law. It had been codified internationally in the UK, in Scotland, and Ireland. And as Zeal said, there's momentum. There's a lot of momentum nowadays to build this concept into existing laws. But in 2019, we didn't have this definition. And that was the whole point of that legislation, Senate Bill 1141, to name this specific harm, which is really a harm that deprives a person of their free will and personal liberty. It is, it doesn't have to be physical. In fact, a lot of the time when somebody is committing coercive control, they're not resorting to physical violence. And that is because they've managed to subdue a person through various techniques that essentially subjugate the person, deprive them of their free will, autonomy, and personal liberty, and reduce them to a shell of their former self. And so examples of this behavior, which are all listed in the law, include isolation, deprivation of necessities, controlling, regulating, or monitoring the other person's movements, communications, behavior, right? All of these freedoms that we have, that we take for granted, are taken away from a survivor of coercive control. It can also take the form of threats based on immigration status, or really any kind of threat that results in compelling a person to behave in a certain way or to not behave in a certain way. And then reproductive coercion was added in 2022 through a different Senate bill. And that it is an example of coercive control because it is a way in which an individual is prevented from exercising autonomy over their body and their reproductive decisions. Okay. So this is, again, all part of the family code definition of domestic violence. It's not part of the criminal code. When I first started working on this legislation, I actually did try to add it to the penal code to criminalize coercive control, but it didn't work out that way. And that's, that we don't have time to go into that. That's a presentation for another day. But as it stands, coercive control is a form of abuse under the family code. It is not a crime under the penal code, but it does intersect with the penal code, right? So we're talking about systems, navigating systems. These systems do interact with each other, and we'll talk a little bit later about how coercive control does actually come into play in criminal law, even though it is not itself a crime.
Got it.
So now, talking about systems, we are going to discuss the prosecuting agencies in LA County and what it looks like now for a survivor to navigate the criminal justice system. So we're stepping away from the family code for now, and we're going to focus exclusively on the criminal court system, what that looks like, the rights and resources of victims, and common questions that come up in this context. And then we'll move back towards the family code to talk about the intersections between criminal and family law. So for those of you who don't know, there are two main prosecuting agencies in Los Angeles, the district attorney's office and the city attorney's office. And I've worked for both. The district attorney prosecutes all felonies and misdemeanors in unincorporated parts of LA County. So those areas that aren't cities, but that are unincorporated and fall under the county limits. And then the city attorney prosecutes exclusively misdemeanors within the city of Los Angeles. So you might be wondering, what's the difference between a felony and a misdemeanor? Well, a felony is a crime that carries the potential for punishment in the state prison for up to life. It could be life with the possibility of parole or without. Certain felonies also carry the potential of the death penalty, although that isn't pursued in California. Now it is in other states. But so you get a sense of the difference. It's really in the level of exposure that a person who commits the crime faces. And so for the misdemeanors, the maximum punishment for a single misdemeanor is 1 year in the county jail. Whereas for a felony, it could be prison indefinitely. So that's the major difference. Now, whether a crime is a misdemeanor or a felony, that decision is made. There are certain crimes that are always going to be felonies, like murders or rapes. And there are other crimes that could be felonies or could be misdemeanors. So, and we'll talk about how that determination is made and by whom in a moment. But first, I want to sort of talk to you about what it looks like before that decision is ever made. There has to be a crime, right? Before it can be determined whether it's a felony or a misdemeanor. A crime has to take place. Otherwise, the prosecuting agency will never see it. So what will typically happen is that a crime will occur. And obviously, we're talking about domestic violence here. So we'll say a domestic violence crime will happen, and the police will get called out. Now, it's not always the victim who is calling the police. In fact, with domestic violence crimes, a lot of the times it's not the victim who calls the police. It's a family member, or it's a neighbor, or it's a stranger who happens to witness a crime in progress. It is sometimes the victim, but what's important to note here is that a lot of times when the victim does call the police, it's not the first time that the abuse has happened. It's just the first time that they're reaching out. And it's usually because the abuse has reached a level at which the victim is now afraid for their life or their life of somebody they love, like a child. Mm. And so the police will respond to the scene of the crime. And these officers who respond are called patrol officers or responding officers. And their job is really just to determine what happened and is there enough evidence to make an arrest. Let's say they decide there's enough evidence to make an arrest. That happens because they've talked to the victim and they've seen injuries. They've talked to witnesses, and they've done a preliminary investigation that leads them to believe there's enough evidence now to make an arrest. So they'll make an arrest if the offender is still there. And if the offender is not there, they can get a warrant for the person's arrest. Again, if they believe that there's enough evidence that a crime has been committed. for domestic violence crimes in California, there is a mandatory arrest policy. So it's not the case anymore that a victim can say, I don't want this person arrested. The officers will arrest if there's evidence to arrest. Now, after the arrest, the patrol officers will write up a report, an incident report, and for almost every felony and for most misdemeanor domestic violence cases, there's going to be further investigation. So that initial response is not the end of the law enforcement role. There's usually a detective who will then take over the case and conduct further investigation. So they will look into whether the person has a record, if there are injuries, they will, they'll follow up with the victim. Even if they're not injuries, they will follow up with the victim and do another phone call, talk to the victim. They will investigate if there are other witnesses. And the whole point of this investigation is that they're getting the case ready. They're getting it ready to present to the prosecuting agency for a filing decision. So they will present it to either the DA, the district attorney, or the city attorney's office. There are some cases that will always go straight to the district attorney's office. And those are cases that are always those felony crimes, like murder or rape. And actually, the DA and the CA in LA have an agreement that certain domestic violence crimes will always go first to the DA to decide whether to file that more serious felony charge before the city attorney will look at it. So let's say, so we can put this into concrete terms. Let's say the detective takes the case to the district attorney's office. The district attorney's office has filers, they're filing attorneys, and the same is true of the city attorney's office. And the attorneys who file have one job. Their job is to decide. It's a really powerful job, right? I'm not trying to minimize it. It's extremely powerful. They have a ton of discretion. Everything that flows from a criminal case is decided at this point in time when the decision is made whether to file a case, and if there is a filing, what charges to file. So let's say that the filing attorney in the DA's office is looking at the case. They're making a determination on whether there's sufficient evidence to file. And this is a high standard. So the standard of proof in a criminal case is beyond a reasonable doubt. That's the standard to convict a person of a crime in court. That standard is the same standard that applies at the filing stage. So a filing attorney, whether it's somebody at the DA or the CA's office, is making a determination on whether the evidence supports, whether if believed, the evidence would prove guilt beyond a reasonable doubt. Okay, so they can make that decision in the affirmative. They can say there's sufficient evidence, and then they will file the case. They can decide, because it's such a high standard, maybe they believe the victim, but there's not sufficient evidence to prove it. Then they will probably reject the case. They actually are supposed to reject the case in that instance. The DA might decide that there is not sufficient evidence to file a felony, or that a felony isn't warranted. And we're going to talk about what that decision looks like, right? Because it's not just for the DA a decision on filing or rejecting. They can decide to refer it to the city attorney if they don't file a felony. And then the city attorney can decide whether to file a misdemeanor. So there's a few different options at this stage. Now, the main difference here between the DA and the CA is that the city attorney only prosecutes misdemeanors. So they're not going to be filing any felonies. They might look at a case and think it's a felony, and they can send it back to the DA and say, actually, this looks like a felony. There's another option that the city attorney has. So they can file, they can reject, and the standard of proof is exactly the same, whether they believe the case can be proven beyond a reasonable doubt. But there's this alternative to prosecution in the LA City Attorney's Office. This doesn't exist in every city attorney's office, but it does in LA, in my office, and it's called the City Attorney Hearing. This is an alternative to prosecution. So here's what's important to know about domestic violence charges in California. They, for the most part, can be filed as a felony or a misdemeanor, with limited exceptions like rape or murder. The other thing to remember is that there are charges that are known as DV-specific charges, and they're called DV-specific or domestic violence-specific charges because they can only apply to domestic violence relationships or domestic violence cases where you have that intimate partner relationship or former intimate partner relationship. So these are cases that only, or crimes that only apply in the domestic violence context. And then there are what are known as DV-related charges. And this is kind of a term, I guess, I don't know where this came from. I don't think I made it up, but DV-related and DV-specific, but this is how I think of it, because DV-related are charges that are equally applicable to strangers, right? It isn't that these would only ever apply in an intimate partner relationships. These are crimes that can take place between strangers as well. They also happen really frequently in the intimate partner relationship context. And you'll see here, if you just take a quick glance at the screen, that again, most of these charges could be filed as a felony or a misdemeanor. And that is true across the board for domestic violence charges. So again, the DA's office is the agency in LA that prosecutes felonies. They prosecute misdemeanors if they happen in unincorporated parts of the county. And then the city attorney's office prosecutes only misdemeanors in the city of LA. So you won't necessarily know if you see a case what agency it is being handled by just by looking at the charge. Because so many of these DV crimes can be prosecuted or filed as felonies or as misdemeanors. So, but it's the DA's office that will decide when they're looking at a case that can be filed as a felony or a misdemeanor, whether to file a felony or whether to refer it to the city attorney's office, assuming it happened in the city of LA, for misdemeanor consideration. And that is a huge decision. So the power is entirely within that the hands of the filing prosecutor in the DA's office. When they're looking at the case, remember the crime happened, the patrol officers responded, they took a report, they took it to the detective put together a filing packet, did the further investigation. Now the detective is taking the case to the DA's office, and the DA is looking at the case and deciding, for all of these crimes that we just saw on that slide that could be filed as a felony or could be filed as a misdemeanor, what am I filing? This decision is not going to be in play if it's a felony like a murder or a rape. But for all of those, the slew of crimes that could be filed as either a felony or a misdemeanor, here's what the DA is going to be looking at. Does the person have a criminal record? Is there a history of violence, domestic violence in particular, whether that has been reported or unreported by the victim? Because we know that a lot of times victims do not report. So we're looking at that. The attorney is looking at whether children were present. Were they harmed? Did they witness the violence? Were they physically harmed, emotionally? How many victims were there? How serious is the injury? Is it minor? Are there any visible injuries? Maybe there are no visible injuries. That doesn't mean it wasn't serious. For instance, with strangulation cases, there's not always visible injury, but those cases are strongly correlated with lethality. And I wish that strangulation cases always resulted in a felony filing, but they don't, because they can be filed as a felony or a misdemeanor, right? So the attorney is looking at all of these factors. Was there a weapon? And the more of these factors that exist in any given case, the more likely the case will be filed as a felony. That is not to say that it will always result in a felony. So you might see a case, you might be meeting with a victim and they might tell you what happened, and you might think that should have been a felony, and you might be right. But the decision that was made by the prosecuting attorney might very well be different. And that is just because two reasonable people looking at the same set of facts might come to very different conclusions. And there is that opportunity or discretion in the law for a lot of these cases to file it as a felony or a misdemeanor. So you'll see that, and I've seen that a lot, where I've looked at a case and I've thought, maybe this could have easily been a felony and it wasn't filed as one. Going back to the city attorney hearing, because I think it's important that you understand this does happen. It does occur in domestic violence cases that are misdemeanors. So we're going to talk about what it looks like once a case is filed, whether it's a misdemeanor or a felony, how it moves through the criminal court process. The city attorney hearing is an alternative to that process. It will never see the inside of a courtroom if it's set for a city attorney hearing with I guess I never say never. It might see the inside of a courtroom, but it's very unlikely that it will. And here's why. The whole point of a city attorney hearing is to avoid the courtroom, to avoid the filing process and the prosecution, because the attorney in the city attorney's office who has looked at the case has decided that formal prosecution isn't appropriate. A lot of times they've made that decision because there isn't enough evidence to reach that really high standard of beyond a reasonable doubt. It might be just on that line and or just below that line. So the attorney might not feel comfortable filing the case, but they believe that intervention of some sort is needed. So what happens if a case is set for a city attorney hearing, and it does happen in domestic violence cases, is that both sides, both parties, the victim and the offender, will be referred for separate hearings. The offender is known as the respondent if in this context. So the respondent meets with a hearing officer that's just an employee of the city attorney's office who handles hearings and who will talk to the respondent about what happened, give them like an admonition, don't do it again, try and educate them and give them treatment options like domestic violence classes. And then separately, the hearing officer will meet with the victim, talk to the victim about what happened, and link the victim with resources to help them recover. If the case was set for a city attorney hearing and it could have been filed, but it wasn't, the prosecutor retains the power to file the case if there is reason to. So maybe the respondent is told to take classes and they don't, or they're told, maybe they violate the law again, or they violate a protective order. The attorney, if they know about it, will have the option of filing the case. What's important to remember about city attorney hearings is that they're not really, the consequences have no teeth. Like they're not, for the most part, if somebody doesn't do what they're told to do, there's no consequence other than filing the case. But the case has to be fileable in the first place. And a lot of cases that are set for city attorney hearing are set because, again, they don't meet that filing standard. And somebody has decided there should still be intervention, but we can't file the case. If the case is fileable and the decision is made that maybe it should be filed, the attorney can always file it, and then it will go through the criminal justice system in the same way a case would if it were filed right away without being set for a city attorney hearing. This is really an opportunity for the offender. and it doesn't always work. And that is true, especially in the domestic violence context, which is why it's used very sparingly in this context. If a case is filed, whether it's a felony or a misdemeanor, this is the process it will move through. This is the life of a criminal case. It's a simplified version. I haven't broken everything down into its component parts because we don't have time to talk about it, but this is a really, it's a really broad overview of how a case moves through the criminal court system. So let's say a case has been filed. That first court appearance is called the arraignment and plea. This is the stage at which the offender, who is now, by the way, called the defendant, is presented with the charges against him or her. So they're told, and it's like a formal document. It's called a complaint, and it lists the charges against the person. And that person is the defendant is presented with the charges formally at the arraignment and plea. So at this stage, the judge will also set bail, and the judge will also issue a pre-trial or pre-conviction criminal protective order in a domestic violence case. That is always requested. And that pre-conviction criminal protective order is valid throughout the duration of the case. It is valid up until the point of a conviction or a plea. And at that point, if there is a conviction or a plea, a new criminal protective order will issue that is called a post-conviction protective order. Okay, so we have that arraignment and plea. That's the first day the defendant is in court. They're told the charges against them. A criminal protective order is issued, pre-trial order, bail is set. The defendant has two options at this point. They can plead to the charges. They can plead guilty. That almost never happens, but that's an option. Or they can plead not guilty. And that's typically what happens at that first court date. So if they plead not guilty, let's just go through the whole system as if, we're going to take it to the very conclusion. And then we'll come back to what a guilty plea, what that looks like. And after a guilty plea, there's a sentencing, but we're going to table that for now because we're going to play this out as if the person is asking for their trial. They're going to plead not guilty throughout. So they plead not guilty at the arraignment and plea, and then a pre-trial is set. So it's not just one pre-trial. There's usually several pre-trial conferences that could take months. If it's a really serious case like a murder, it could take a year, maybe more. And that's because the pretrial is really where everything's happening behind the scenes. So the prosecutor is meeting with witnesses, they're meeting with the victim, they're getting evidence, they're coming up with an offer to settle the case. And the defendant and their attorney, they're also preparing the case. They're talking to witnesses. They are deciding if they want to settle the case. Maybe they don't want to settle it. Maybe they want to go to trial. So the parties are exchanging information. Maybe they're talking about settling the case. They keep coming back to court to update the judge. And the pretrial phase can involve different motions. So the two sides might be fighting over different, issues, and they're coming to court and they're litigating different motions, and the judge is making decisions. For a felony, there's what's called a preliminary hearing. That's like a pre-trial hearing where the judge decides if there's enough evidence to go to trial. So lots of hearings, lots of behind the scenes conversations and trial preparation happening during this phase. At any point during the pre-trial phase, which again can take months, the defendant again has two options. They can plead guilty or they can plead not guilty. We're going to assume they're pleading not guilty so we can see this through. At a certain point, the judge will say, are we going to try this case or are we going to settle it? Because the defendant has a right to a speedy trial. And guess what? So does the victim. So at a certain point, the judge will decide it's time to set the case for trial. It's not resolving. Now we have a trial. That's where both sides will present evidence. It's the prosecutor has the burden of proving the case beyond a reasonable doubt. This will usually happen with a jury. Sometimes they can elect to have the case tried to a judge. Both sides have to agree. Usually it's a jury trial. A jury is composed of 12 individuals, but part of the trial is selecting the jury. It's one of the, most important parts of the trial. It's very interesting, and it's a way to select jurors who will be fair, who will decide the evidence, or make a decision based on the evidence. And that's the stage at which you're really trying to understand what people's views around domestic violence are. So it's so important because there are so many misconceptions about domestic violence and expectations of victims. So you want to kind of educate the jury at that point. Then once you have a jury, there's opening statement, evidence is presented, the victim will have to testify at the stage. And the defense, they don't have to do anything. They can sit back and just watch the prosecution case, and then just argue that the charge hasn't been proven beyond a reasonable doubt, really high standard. But a lot of times the defense will put on a case and they might call the defendant to testify. This whole process could go on for days, weeks, months sometimes, depending on the nature of the charge. And at the end of the day, when the closing arguments have been delivered to the jury and the jury has been given their instructions on the law, they have to decide. Now the power is in their hands. They all have to be unanimous. They all have to agree. Every single person on that jury has to come to the same conclusion. They can decide that the defendant is guilty. They can decide that the defendant is not guilty. And they might not be able to reach a decision at all. Maybe some of them think the defendant is guilty. Some of them think that the defendant is not guilty. If, despite numerous efforts at trying to reach a agreement, they still are unable to conclude one way or the other on guilt, the judge will declare a mistrial. The jury is known at that point as a hung jury. The case will get dismissed and everything starts over again from that pretrial phase. So you can imagine a mistrial, it's not ideal. It's not ideal for the prosecutor. It's not ideal for the victim who'll have to come back and testify. And there's no closure. But there is that opportunity for a new trial. There are certain instances in which the judge will dismiss the case and will not allow a new trial to happen, but that is the exception. If the person is found not guilty, that's the end of it. There's nothing left to do. The case is dismissed. If the person is found guilty by the jury, or, if they at any point plead guilty on their own, the judge has to decide, now what do I do with this person? What is their appropriate sentence for the crime? In a domestic violence case, there are a few mandatory conditions of sentencing. And sentencing can look, it can take a few different forms. So again, depending on the seriousness of the crime and whether it's a felony or a misdemeanor, the person could go to prison if it's a felony. They could go to jail if it's a felony, or they could go to jail if it's a misdemeanor. The court might decide to put the person on probation. And that's, it's an opportunity for the defendant to, for a period of 3 years, stay out of trouble, not commit any new crimes, comply with certain conditions. And then maybe, at the end of that, the probation will be over and they can go on with their lives. The judge might decide to do a combination of these options. Maybe they put the person on probation and they give them some jail time. If they are put on probation, there is a mandatory condition in a domestic violence case that the person complete 52 weeks of domestic violence counseling. That requirement does not apply if they're not on probation. The other mandate for really any crime is that if someone has suffered damages, if a victim has suffered monetary damages as a result of the crime, they are entitled to restitution. So basically payment for whatever damages they've suffered. And again, in a domestic violence case, there is a condition that the judge can impose, and usually does impose, that is a post-conviction protection order. So that pre-trial or pre-conviction protective order that was issued at arraignment and plea is no longer valid because now we have a conviction. Now we need a new order. And that pre-trial order was valid only while the case was open and pending. The post-trial order in a domestic violence case can be valid for up to 10 years. And that is true whether a person is sent to prison or jail or put on probation. So this is just the language from an actual criminal protective order. It's a pretrial order, so it's only valid during pretrial. Once the pretrial phase is over and we have a conviction, then we have a post-trial order. Again, it's valid for up to 10 years. So this is something you don't really need to worry too much about. There's a couple of options for the court issuing an order. And if they're issuing the order as a condition of probation, the order is only valid during probation. So it's important to note that not every protective order issued in a domestic violence case is valid for up to 10 years. The law gives the judge the option to issue it for up to 10 years, but it could be less, and it could also just be valid during probation. The judge will make that determination based on the seriousness of the facts and the probability of future offenses, as well as the safety of the victim and the victim's family. Okay, so we've talked about the criminal court system, how a case moves through the system. And we also talked about the definition of abuse. Now, when it comes to criminal protective orders, worlds will collide. The penal code and the family code intersect here in a really, really important way that I want to mention. A person who is subject to a criminal protective order will be ordered to not abuse the victim. And here's the language from the criminal protective order. You'll notice here that although this is a criminal protective order, the language in the order to not abuse references disturbing the peace and defines disturbing the peace in the way that we talked about earlier, the family code definition, the destruction of a person's mental or emotional calm. And it also references the definition of coercive control, which is a subset of disturbing the peace now under the law in the family code. But even though it's in the family code, a criminal protective order prohibits disturbing the peace and prohibits coercive control. So what does this mean? It means that even though coercive control is not a crime, a person can commit a violation of a restraining order by committing coercive control. And if they commit coercive control in violation of a restraining order, that is a crime. Violation of a restraining order, whether it's a domestic violence restraining order in family court or whether it's a criminal protective order issued in criminal court, violation of a restraining order is a crime. It can be filed as a felony. It can be filed as a misdemeanor. So again, if a person subject to a protective order in criminal or family court commits coercive control, they can be charged with the crime of violating a protective order, and they can be punished because violating a protective order is a crime, even though coercive control is not a crime. Victims have rights that apply throughout the criminal case. These rights are in the Constitution, they're the state constitution, they're also in the state statute and the penal code. I've selected several of the most common rights. It's really about being treated with fairness and respect, having their needs and safety considered, having the right to be informed, the right to refuse to speak to a defendant or their defense attorney. So they have a right to a speedy trial. They have to request a lot of these rights. So what will happen when a case is filed is that the prosecuting agency is supposed to tell them, notify them of their Marcy's rights. The city attorney's office does it through a letter. They'll mail a letter to the victim, and the letter will detail all of these rights. And they will know when they have to request their rights, because it will say, upon request, the victim has the right to. So it's important to note that they have to request a lot of the rights. The other thing I want to point out here is that there's a difference here between, there's a distinction to be drawn between a prosecutor's responsibility and the responsibility of another lawyer for the victim or a victim advocate. So prosecutors are not the victim's attorney. Prosecutors represent the people of the state of California. They don't have a client in the victim. Their client and their responsibility is to the public at large. People forget this all the time. Victims forget this. And it's important that we remind victims, because otherwise the victim will have an expectation that the prosecutor cannot meet. And the victim will be really disappointed when they realize that the prosecutor has to tell the defense attorney whatever the victim tells the prosecutor. So there's no confidentiality between a prosecutor and a victim. The prosecutor is obligated under the law to disclose information to the defense. That duty trumps confidentiality. That's not the case for, say, family lawyers, right? Or other lawyers representing the victim. So if a victim needs to understand, and it's really incumbent on the lawyer and the prosecutor to explain their duty. And this comes up in another really important way in the domestic violence context. You may have heard, the language of dropping charges, or like when a victim drops charges, or the victim filed charges. So the victim can neither file charges nor drop charges. The victim doesn't have the right to decide what filing decision is made, whether that's to file a case or to reject it or to refer it to a hearing. The victim, because the victim is not the prosecutor's client, the victim is not in charge. And this comes up all the time in the domestic violence context, where the victim, for whatever reason, and there are oftentimes very, very valid reasons for not wanting to pursue a prosecution, the victim will say to the prosecutor, I do not want to pursue this case. I want the charges to be dropped. And if there's evidence to pursue the case, and there should be, because it wouldn't have been filed otherwise, the prosecutor will have to tell the victim, I'm sorry, we're not dropping the charges. We're not dismissing the case, because our obligation is to prevent this person from committing the crime again, whether the crime is committed against you or another victim. The obligation is to the public safety writ large. And so you as a victim do not have the right to drop charges. Now, that doesn't mean the victim doesn't have the right to be heard. So they have the right to confer with the prosecutor and explain their position and why they don't want to prosecute. They have the right to be heard in the courtroom by the judge at certain proceedings where their rights are affected. But the ultimate decision on filing and prosecuting rests with the prosecutor, not the victim. Okay, I think I'll pause here for a moment. Maybe check in to see if there are questions before we turn to new laws that are effective next year. Not every new law, we're only going over a certain number that are most relevant to victims' rights and resources. But I'll pause for a minute to see if there are questions. Let me check the Q&A. Okay. Interesting. Both really, really good questions. All right. So what are some subtle or not obvious abuse? That is the $1 million question. you know, there are, with the coercive control law, and I can go back to, let me just go back to it. When we're writing this law, we were trying to capture the most common forms of abuse, of coercive control, but we weren't able to list everything. So financial abuse, absolutely. Economic abuse, yes. Litigation abuse is a huge one, right? Use of systems like false reports to the police, or children and family services, or immigration authorities to control the victim. Use of the family court, which we're actually going to talk about briefly in the context of one of the new laws, is a really, really common method of controlling a victim. Litigation abuse, where a person is, their finances are totally depleted through misuse of the legal system, especially family court, to file motions that have no merit over and over and over again, forcing the victim to come to court, to take time out of their schedule to spend money until they're really they're basically held hostage. That's really what coercive control is about. And so a lot of the more subtle forms of abuse fall under this rubric. And so we weren't able to list everything, but we have this sort of catch-all category number 4, which is compelling the other party to behave in a way or to take action that they have the right to not do, or that, or forcing them to not engage in action or in conduct in which they have the right to engage. So this is meant to capture all those forms of micro-regulation where the abuser is telling the victim what to do, compelling and securing their compliance through force, threat of force, or intimidation, and doing so in a way that prevents the victim from exercising their autonomy. So, I mean, these are the most common ways in which a person can commit abuse. Again, the other ways that I've listed, there's so many. I mean, if there are people in this group who want to add to this in the Q&A, please do. Abusers will find any way to abuse. Oh, I'm sorry. Yes.
No, you're fine. I was
Yeah.
People have added to the Q&A.
Yeah. Okay. So anyway, so yes, feel free to, to put in the chat, or sorry, the Q&A, what I'll just end by saying, or this question by saying, that an abuser is usually very skilled at finding ways to abuse, and what abuse of one person to an outsider, what might not look like abuse, might very well be abuse for this particular victim. So it's very fact specific. It depends on the context of the relationship, and it will look different for different survivors. Okay, is DV against a pregnant woman considered an aggravating factor? It's not, well, it's considered an aggravating factor for sentencing purposes. So, if a person is particularly cruel in the way they commit a crime and the victim is particularly vulnerable, that can weigh in favor of a higher sentence. So in that sense, yes, it's an aggravating factor for sentencing. It's not, unless the victim suffers a serious injury, it's not an aggravating factor in terms of what can be filed, but it is in terms of a sentence imposed by the judge. Yes. Yes, there's another note here about financial abuse, blocking access, all of that. Yes. Okay, so Sarah, you know what? You can just reach out to me. I think my email's on the PowerPoint. Oops. Sorry. I'm moving multiple things at once. Yes, so here's what I'll say about that. Let me just get back to the other slide. Here's what I'll say about this generally. And this is a pet peeve of mine. So I could talk at length about this, but this is a huge issue for me, that victims are often, wait, sorry, should I go back? What slide should I go back to? Should I go back to coercive control?
Not sure, Asha, you want to put which slide you were referring to?
Okay, well, in the meantime, I'm happy, and you'll get a copy of this PowerPoint, by the way. So, and you can always reach out if you have questions. I'm available to talk. But let me just say this about victims of crimes, and prosecutors and advocates and, law enforcement. It's not everybody, but a lot of times we forget that there's a victim and that we need to keep victims apprised of updates in their case. Uh, you know, Having been a prosecutor for so many years, I know that that is not always done, even though that is what should be done in every case. Every domestic violence case, we should be notifying the victim of updates especially when there's a long pretrial phase, so that the victim has that information and they can use that information. Even if they don't do anything with it, it's power, right? Knowledge is power. To have that, to know what's happening with the case. It really goes a long way. So if there is a question, the other thing I want to say about this is that there are some changes that are happening both in the city attorneys and district attorneys' offices, organizational changes that when I saw what was happening, I worried this would trickle down to victims. I'm not saying that's what's happened here, but the fact that you're not hearing from the city attorney or the prosecutor is kind of, for me, it's a troubling sign that, that there's maybe, there's obviously a lack of communication. I don't know if it's speaking to something broader or if it's just this particular case. It doesn't matter for your purposes. All you want is information. And so you can get that by contacting me offline. I will find out if you have a case number. That goes for everybody. I will do my best to get you that information. So please reach out. Okay. Kinjal, yes, also reach out to me offline. Technically, you guys, I'm not supposed to give legal advice, but I can give you information. And there are actually, one of the new laws we're talking about is immigration related. So maybe that will shed light on that situation. Blocking financial access, 100%. Yes, that is abuse. Mental damage, it is taken into consideration. So like if somebody suffers mental harm and they're going to therapy, they can get reimbursed monetarily for their therapy. So in that sense, they are considered injuries for restitution purposes. I don't know if that's the question or if it's something else. Sarah, but if you're talking about for restitution purposes, it is, yeah, I don't want to assume. So you feel free to reach out or clarify. Oops, I'm so sorry. Okay, I'm just going back. All right, so I think that's all in the Q&A. Did I miss anything? I'm not sure, Asha, which slide you want, but I do think maybe, and I'm sorry for that. I've lost track. So maybe can we move on to the new laws and then circle back if there are other questions? Yeah, okay. There are a lot of domestic violence laws that take effect next year. In a way, we're actually lucky to live in a state that's at the forefront, I think, of legislative change, but we can't talk about all of them. So again, I selected the ones that I think are most relevant to survivors because they directly impact their rights. And I didn't limit this to the criminal context. I went a little bit outside of that to the family law context because I know that victims are not just engaged with criminal law, that they're moving through multiple systems. So I did want to touch briefly on what that looks like. Especially in the family court context where we know that abuse happens even after a victim and their abuser have separated. The abuse does not stop. In fact, it can be, it'll just look different. It will be happening in a system and an institution that is meant to protect the victim, and instead the system will be weaponized against the victim. So we'll talk a little bit about how the laws that go into effect next year are meant to mitigate against that continuing harm and form of abuse. Okay. Assembly Bill 1261 is a bill on, it's for victims of domestic violence and human trafficking and other crimes. We're just going to focus on the domestic violence component. So just some background, because I'm not sure how many people are familiar with the U visa. It was an immigrant status created by Congress in 2000 through the Federal Victims of Trafficking and Violence Prevention Act. It created the U visa immigrant status, which provides temporary immigration benefits and a pathway to citizenship for victims of qualifying crimes. So, one component or one aspect of the U visa application is what is called a law enforcement certification. It's a form that has to be filled out by a law enforcement agency. And the whole point of the U visa is to encourage undocumented victims with vulnerable legal status, encourage them to come forward when they are victims of crime, encourage them to cooperate with the law enforcement and prosecution process so that public safety can be enhanced and communication between law enforcement and our immigrant communities can benefit. So from partnerships and from cooperation with the criminal court process. So with that in mind, if a victim is seeking U visa immigrant status, they will have to get a certification of victim helpfulness from the law enforcement agency that is involved in their case. This is one component. It's necessary for the application. It's not by itself sufficient. There's a whole separate application and process. I'm not an immigration attorney, but my office is a certifier, and I oversee this process in my office. And we have a web page dedicated to U visa certification, in which we also link to immigration lawyers and agencies that can help with the application. But the law enforcement and prosecutor's role is limited to certification of victim helpfulness. And that involves determining these three factors, whether these factors are present. One, is the person a victim of a qualifying crime? So the U visa immigrant status is available to certain crimes, certain crime victims, not all. Domestic violence is a qualifying crime, stalking, rape, sexual assault, false imprisonment, in which a person is kept from going somewhere, so they're held in their home against their will. These come up very frequently in the domestic violence context, so I've listed them here. This is not an exclusive list of qualifying crimes. So the individual has to be a victim of a qualifying crime, and they have to possess credible and reliable information about the crime, and they have to be helpful to the prosecution or conviction. This doesn't require that a case ever be filed or that the person get convicted. It just requires that the individual seeking U visa immigrant status be available and helpful as needed to the prosecuting and law enforcement agencies. So when a prosecutor, when I'm looking at a U visa certification of helpfulness request, I have a few different choices. I can grant the certification, I can deny it, or I can refer it if it belongs to a different agency. Say it comes to me, but it's actually a district attorney case. I can send it to the DA's office. If these three factors are present, I will grant the certification. I will sign off on these factors. The victim is the victim of a crime and they've been helpful. AB 1261 is a law that is meant to clarify the responsibility of a certifying agency to the benefit of victims. So if an agency like my office is denying a certification, they have to explain why. a lot of times in domestic violence cases, as we talked about, victims don't want to cooperate. They don't want to prosecute. They don't want anything to do with the case. And that isn't necessarily always true. And it's not even always true throughout the duration of the case. A victim might start out uncooperative and become cooperative, or they might start out cooperative and become uncooperative, right? So they're cycling through different stages. And so the law has a rebuttable presumption that a victim is helpful as long as they haven't refused to provide information reasonably requested by law enforcement or failed to provide information reasonably requested by law enforcement. So the presumption favors the victim here. And AB 1261 builds on that presumption by stating that if a victim claims they weren't aware of a request to cooperate, their failure to cooperate does not rebut this presumption. Let me give you an example. We might send a subpoena for the victim to come to court to testify, and we might send it to their address, and we might never hear from them. So we might send out an investigator to go look for them, to tell them, hey, you have to come to court. You've been subpoenaed. There's a trial. You have to testify. And maybe they can't find the victim. And they try, and the victim is nowhere to be found. Now, fast forward a few years later, the victim is requesting a U visa certification of helpfulness. Well, I look at that case and I say, oh, the victim wasn't helpful. They didn't reply to the subpoena. Sometimes the victim isn't replying because they've gone into a shelter or they've moved to get away from their abuser. And that's a reasonable failure to cooperate because they weren't aware of the request. So that's now codified in the law that if they were unaware, that doesn't mean that they, if their unawareness was reasonable, they're still presumed to be helpful. And then the other addition here is that, and again, I think this is really useful in domestic violence cases because they're repetitive, they're cyclical. You tend to have a lot of incidents between the victim and the abuser. And it might be that the victim didn't want to cooperate in one case, but they cooperated in a later case. And so the certification can be granted for the case where they cooperated, and it can't be denied just because they refused to cooperate in an earlier case. So I pulled out this language because I think, again, it's beneficial for victims of domestic violence, and it tends to make that whole certification process less burdensome for them. Senate Bill 86, it builds on Marcy's Law, those rights that we talked about, some of which have to be requested by victims. So these are rights that victims don't always know about. And now there is already a website in California that's operated by a crime victim center that has information about victims' rights, but SB 86 takes that a step further by requiring the website to include certain information like a summary of the criminal justice system process, legal protections for victims, links to resources, and information about victims' rights. So this should all be now, maybe not now, but soon available on a website. And again, this really centers the needs of crime victims by making information readily available to them. I actually don't know if this is accessible in multiple languages. I will double check on that. I'm hoping that it is. So it's worthwhile looking into it. Senate Bill 290 makes the process for getting information from law enforcement agencies a lot easier. So why do victims need information from law enforcement agencies? Well, they might need a copy of the police report for family court, right? They may want to go to family court and ask for a restraining order, and they need to prove a past act of abuse. And that proof can come in the form of a police report. So victims will often go to the law enforcement agency that handled their case and ask for a copy of their report. They might need it for the U visa, right? To show that they were the victim of a qualifying crime. And so the rule or the law has been that the law enforcement agency has to provide a copy of that report, the incident report, which is the report that those officers take when they first respond to the scene of a crime, right? The law enforcement agency on request has to provide that at no cost to the victim. And they have 5 days to do that, unless they can show good cause. Maybe their system is down or they can't access it for whatever reason. And then they have 10 days. So within a reasonable amount of time, they have to give that information to the victim. Senate Bill 290 expands on that law by requiring the law enforcement agency to also provide on request photographs of a victim's injuries or photographs of property damage, any photos that were taken in the course of the officer's response to the crime, as well as any 911 recordings. So this is all information that the victim should now must get upon request within 5 days, 10 at the latest, and that they can use when building their case in family court, when seeking, maybe they're seeking civil remedies, right? It's all meant to equip the victim with information that they are entitled to by making this a legal right now. So hopefully this will benefit victims. Okay, Assembly Bill 467. So we talked about protective orders. We talked about pretrial and post-trial protective orders. AB 467 applies to post-conviction protective orders only. And it applies to those protective orders that are issued for, it actually applies to orders no matter their length. So, but it really is meant to apply to orders that are issued that are not a condition of probation. Because what would happen historically is that a protective order would be issued by the court and it would be valid. Let's say it's valid for the maximum of 10 years and the person isn't on probation, or they were on probation, but their probation expired after 3 years, and you still have this protective order that's valid for 7 more years, right? So a total of 10 years. So we have a protective order that is valid, but we don't have a mechanism for changing it because the defendant is no longer on probation. They don't have any more court appearances. They're in the wind. And we have this protective order, and the victim wants to modify the protective order. Well, they could go to court. They would have to go to court and tell the prosecutor and the judge they wanted it modified. Maybe they want it, maybe it's not 10 years, but it's 5 years and they want it extended to 10 years. Or maybe it's 10 years, but it doesn't have a provision of that they want. Like maybe it doesn't have a requirement that the defendants stay away from them. And now they want that. Or the opposite could be true. Maybe it does have a stay away provision and they want that removed. So whatever the reason behind the request for modification, some courts wouldn't grant a modification because they thought they no longer had any sort of control over the case because the person is no longer on probation. And that wasn't true. It's not true. This law makes that clear. It states that the order can be modified, that the court does have the power and the authority to change the order if it's still valid. So throughout the duration of the order, it can now be modified. And there shouldn't be any confusion around this anymore. The victim should just be able to come to court and say, I want this order modified. And now they can point to this law and say, it's allowed, it's authorized, this modification. It makes it easier for the victim to get that modification in criminal court. Okay, we're moving. I think this might be the last one. And let me just see. Yeah, it's the last one. So I ended on this one because, again, it kind of brings together the different systems. It's a family court law, but it also, it touches on abuse, and it does so in a way, in multiple ways. So it's named after a boy who was murdered Peaky. He was murdered by his father in 2017. His mother, Ana Estevez, you might know her story. She's an amazing champion for children's rights. She's really been Peaky's voice, and she and Peaky are the impetus for this law. So this all came about through this tragedy where the father of Peaky took him to Disneyland and then smothered him in the backseat of his car and killed him. And his mother, Peaky's mother, Anna, had on multiple occasions told the family court that she was concerned for her safety and the safety of Peaky, and had asked the court to not allow Peaky to be with his father. And the court ignored her warnings and granted unsupervised visitation to the father, who then killed Peaky. So Anna went on a quest to stop this from happening to other children. And it started with a resolution, Peaky's resolution in 2018, I believe, and then has manifested and culminated in this law, which takes effect in 2024. And the point of this law is to prevent tragedies like Peaky's from happening again. I'd like to say that after Peaky's death, it never happened again, but that's not true. Children have been murdered by abusers. It is a way for abusers to continue their pattern of coercive control and abuse post-separation through family court by using the system against victims. And it happens when courts discredit allegations of abuse by mothers, usually protective mothers, and award custody. It's not, to the abuser. It can happen with fathers as well, but the data shows that mothers in particular are penalized when they raise allegations of abuse. In family court, custody is taken away from them, and this can result in the child being forced to reunify with their abuser through a really harmful practice I didn't know a lot about until I started working on this bill, called reunification camp. It is where the child is taken from their protective parent and cut off for a period of time that can start at a minimum of 90 days, but can go on for months. And during that time, the child is put through a really harmful practice that is meant to fix the relationship with the abuser. A lot of times the child is threatened that they're not going to see their family again unless they recant their abuse allegations. And the protective parent is prohibited from contacting their child. If they do, that period of no contact can get extended. It's a really, really harmful practice, and Peaky's law puts a stop to it. You see that the language in the intent of the bill is to prohibit family courts from ordering these camps that are very distressing and harmful to children. The legislative intent is also to just generally increase the priority given to child safety in family court. That is going to hopefully be accomplished through enhanced training curriculum. So the body that oversees judicial training in California is called the Judicial Council, and they are responsible for coming up with curriculum for judges and other professionals. So Peaky's law adds to the curriculum. It adds certain topics like coercive control and child abuse. And the hope here is that judges now and other professionals involved in these cases will be trained, will receive more robust training in child abuse so they can recognize the signs of child abuse and respond appropriately. And then there's the final requirement of Peaky's law is that Judicial Council has to report back to the legislature on the judicial trainings. So all of this is meant, again, it's meant to protect children. It's also meant to protect parents, mothers in particular, who are subject to continuing abuse when they try to leave their abuser, and protect their children. It's meant to stop the harmful practices and methods in family court of punishing these parents just through a better education. And so the idea is to give judges the tools that they need to protect children and to stop abuse and to stop systems abuse and child abuse. So the, legislation alone can't solve all problems. Education is a big part of it, training, and talking and communicating and continuing to monitor and develop new remedies to help survivors. That's what this is all about. It's what I hope to do by talking to you. And I hope that this has been helpful to you. I've reached the end of my presentation, so I want to thank you all for taking the time to be here and open it up. We have a couple of minutes for questions. Thank you so much. Okay, I don't see any questions unless I'm missing it. Can you all hear me?
I can hear you.
Yeah.
Oh, okay. I wasn't sure if I lost the connection. Okay, well, I mean, if there are no questions, that's fine. I have provided my information. If anybody wants to reach out separately, I'm happy to.
Yeah, that was very gracious of you.
Yeah.
Thank you so much. It was so informative, in depth, and yeah, it really shows that you're an expert in this field.
Thank you. And thanks for making the space to have this conversation. Thank you to everyone who was able to attend.
Yes. Okay. And as Pallavi stated, she does have her info stated. And you can always reach out to info@saahasforcause.org if you have any other questions or would like to reach out personally. Okay, with that, you guys, thank you. Enjoy the rest of your Monday and your week. Take care. Bye. Thanks, Pallavi.
Bye, everyone.